switch to a smaller needle size, so the cup was too loose.
Yeah.
I was like, no, you just go in timeout for a while.
Yeah. Well, and I told Emily, I like the act of knitting, and this is a super easy knit. It's all, I mean, there's a little bit of purl stitches at the bottom, and there's a little bit of, make ones and slip, knit and knit two together. That's as complicated as it gets. And it's only around the shaping. And so the vast majority is just sitting there knitting. So it's to redo it, it's not terribly taxing for me.
Yeah, that makes sense. We should do another knitting coffee shop date with Emily.
Yeah, we totally should. I agree. Yeah.
All right, ready to let everybody in?
Let's do it.
Got a good turnout today. Good evening, everybody. Sorry, I was just quickly counting some quorum. It looks like we're all set. Okay. Jason, it looks like you have joined us twice. Is that on purpose?
It is. I'm on vacation and my audio is going to be through my phone. Can you hear me okay?
We can. Yep.
Okay. So sorry if it causes a problem. I think I've got it set up, but I'm sorry I'm here twice.
No, it's fine. Just want to make sure that we don't have like someone secretly lurking pretending to be you. All right. Give folks another minute to join. Got quite the agenda today. All right, it is 5:30. Like the nice lady said, this meeting is being recorded and the live stream is on so that folks can either watch us live or watch us on YouTube after today. Just for ease of use, please remember to raise your hand before speaking. There's a little reaction button on the bottom of your screen and a button that says raise hand. We do have a super full agenda today. So we are going to be covering vacancies and election officials recall and then qualifications of council members. So are there any questions before we get started? Otherwise, I'll just jump right in. Great. So first up is how vacancies are created. So just as a little bit of a refresher, I know this was all in the homework. This is the text for Tigard right now. I'm not going to kind of go into detail about what's in it, but it's largely what you'd expect to see and what's in a lot of other charters. But it's a little difficult to read in that paragraph form. So we also have these examples from Beaverton, who has kindly just listed out, these are the ways that vacancies are created. And then from the LOC, something similar, this is how vacancies are created. And after doing some research, we've got some of this is usually what everybody has in there. This is how vacancies are created section. And then these are the ones that sometimes show up. So why don't we just start with what's usually included. So if someone dies while in office, someone passes away, that usually creates a vacancy. If someone resigns from the office, that creates a vacancy. If there is a recall from office, then that would create ceasing to reside in the city, creates, and then ceasing to be a qualified elector under state law would also qualify. And then there's some requirements for being an elector under state law. We don't have to put that in the charter necessarily, but it's good just to be linked up with what the ORS is saying. So is anyone, let's just start strictly with the usually included. Any questions about those comments? Jason, please.
So on the last one, the ceasing to be a qualified elector under state law, does that need to be included? Because, I mean, isn't it true whether we include it or not? I guess that's my question.
Yeah, it's true whether we include it or not. It's just usually included. Good point. And John.
Yeah, ceasing to reside within the city or any of the other ones, is there a time allotment before it's considered vacant? Because I know what just happened in the school district. It was quite a while before they considered that they weren't residing within the city. So leaving that very generic makes me worry a little.
Yeah, that I haven't usually seen a number of days, but we could certainly add ceasing to reside in the city for more than 30 days.
Yeah, I don't know if I don't know what the good answer is. I'm not saying I want to see it number of days. I'm just saying, something happened, and is there a way that we can make sure it doesn't happen here?
I guess, could you give a little more clarification? What happened with the school board? What was this?
Karen, do you want Karen? I'd rather have Karen say it.
Okay.
Well, if somebody changes their residence and doesn't tell anybody, it's kind of hard to know that they aren't residing in the city anymore. But when you find out and confirm it and find out they've moved, then it just becomes fact. So yeah, as far as preventing it from happening, I don't know how it could have been prevented from happening.
Okay, so maybe more of a requirement that if you move, you have to disclose a new address.
That would be helpful.
Yeah, maybe that's something we suggest though for a council rule.
Just gonna throw out that if somebody still owns property in Tigard, they could claim that address. Just
Kim, this is a stickier wicket than you may be recognizing, just
Oh.
FYI.
No, I'm getting it. It's just that no one else has considered this, and it's always interesting when this group brings up all these scenarios.
Well, and so this also ties into one of our other topics is qualifications of electors, because we have had the conversation, and we're going to talk about it in the in our next or second to the next topic for today. But where the person is registered to vote has been an issue before, and you can tell by the number of times that residency is litigated how controversial it is, whether it's at the federal, state, local level. Even just this past year with the New York Times journalist, that was litigated and went up to the Oregon Supreme Court. So we have had the issue in Tigard where a person has two residences and they are registered to vote in Beaverton, but claims they are residents of Tigard. And so usually the things that we look at are, where's your driver's license? Where are you registered to vote? Where do your utility bills get mailed? And so there isn't really a firm test of what it's a bunch of factors together. It's not one bright line rule as to where you're a resident. And so we have talked about maybe the requirement that you be registered to vote in the city of Tigard, but that even that doesn't address all the topics that have just been raised. And like I said, the fact that it's been litigated so frequently points to the fact that it's not as simple as it seems.
Yeah. Carol, please.
Yeah, so could we just go over what qualified elector under state law is?
Yeah, I think that was in the meeting guide. Let me go look for that. So qualifications of an elector under state laws: you have to be 18 years or older. You have to have resided in the state during the 6 months preceding the election. And then there is an exception. You have to be registered to vote not less than 20 days prior to the election. And then provisions might be made around taxes, but the big things are 18 years or older and have been residing in the state for 6 months.
Right, but none of those tie a person to, living or being even able to vote in Tigard. And that, I just find that really concerning. I mean, that's, you can be a qualified elector. I would like them to live here and be registered to vote here, if that's something we can ask.
Well, it is absolutely something we can ask. Let's table that until we get to the qualified elector stage, although we can certainly put into how vacancies are created if you are no longer a qualified elector under both state law and this charter. Tony, please. Oh, Tony, you're still muted.
Sorry about that. I clicked on the wrong thing. So are we able in this document to set that criteria? Is that something that this document and even the city has the authority to decide what the qualifying attributes are to hold the office? Is it, for instance, can we define what we mean by residing in the city, that they also be registered to vote in the city, have a driver's license issued to some address within the city, just kind of under that ceasing to reside, what are we able to define what reside means and have those criteria? But also to Carol's concern, I think, since these are any of these kind of things, if any of these attributes are met, so I think that ceasing to be a qualified elector, I think if we have that as just one of the means, and then that ceasing to reside, requiring them to reside kind of, is another metric for that of qualifying them for the office. So if they're not residing in here, then we wouldn't want them. I concur that we probably don't want them making decisions for the city if they don't actually reside here.
Yes, so we can make requirements about what qualifies an elector as long as it does not violate the state's requirements about what qualifies an elector. Shelby's nodding, okay. All right. Is there any concern about the first three? Death, resignation from office, recall from office, those are all good? Okay. So ceasing to reside in the city and then ceasing to be a qualified elector under state law or this charter. Knowing that we are going to define it sounds like this group wants to define what it means to be a qualified elector and a resident when we get to the qualified elector. Does anyone feel differently about those? Okay, I'm getting a lot of thumbs up. Okay, so we're going to write that down. We're gonna have a good discussion about the qualifications for an elector in probably about an hour. All right, the ones that are sometimes included, but not always, and we'll just go down this list. So the first one is adjudicated incompetence. And I believe this means a judge there's been some claim that someone is no longer competent for office, and a judge has confirmed that claim. And so this person is no longer allowed to sit in office. And we're just gonna go one by one through these. Does anyone feel strongly about including it or not including this particular provision?
I have a question. How often does this happen? Do you have any idea?
Not often.
No, because I've just never heard of it before. The adjudicated incompetence, so it makes sense.
Jason, go ahead.
That's what I was going to say. If for some reason, I don't think this would happen often, but if for some reason someone was actually determined by a court to be incompetent, they probably shouldn't be serving. I mean, I'm going to go out on a limb there.
Karen.
I think so as well. And what I'm thinking of is that they may not have the ability to resign, possibly. So it does seem like stepping in to, in essence, force that resignation makes sense to me.
Thank you, Karen. And Jeanette, please.
Thanks. So perhaps this is a question for Shelby, but if someone is in office and someone determines, the question mark is who determines their incompetence, how long would it take to adjudicate that? Does it take beyond 4 years?
No, No, so depending on what kind of process it is, so it would be a judge, like Kim said, an adjudicated incompetence is not just somebody saying, I don't think you're fit to serve, but it's actually a court process. So it could be like a civil commitment, it could be like a power of attorney kind of hearing, guardianship, any of those kinds of proceedings could result in somebody being adjudicated incompetent. And those tend to be really quick because of the interests involved. So it would definitely be less than 4 years.
And Zachary, please.
So what would constitute like not being fit to serve? Like someone who had like a mental disability, or like someone who acted like wrongfully in an event, or like all of the above, or maybe an example or something?
Like if someone started to get dementia, or someone had a terrible accident and they were no longer able to take care of themselves, those would all be kind of the scenarios that could lead to adjudicated incompetence. Lindsay, please.
So with the Oregon revised statutes, their vacancies that they list out, is that just in terms of elected officials at the state level then? And that, do you know what I'm talking about? Sorry,
Yeah,
to be more clear.
So no, it does apply to us as well, but it's not it's kind of like oldie language. It's not very specific. So you have incumbent is found to be a person with mental illness by the decision of a competent tribunal. And so
yeah, the competent tribunal is confusing wording. But
Yeah.
yeah, I was just wondering if like where those supersede each other, if this was just referring to people elected at the state level, or if this would still apply at the local level, and like, do we need to be looking at this more closely actually?
This gives us, it's more that it gives us the option to do an adjudicated incompetence rather than doing this. So it gives us both options to.
Okay.
Yeah.
As long as there's something to refer to A through H over here. Is that the idea? Okay. Thanks.
And I did, Lindsay, I looked to see if there was any case law on defining any of these kinds of vague definitions, and there's really not. I mean, to the question earlier, how often does this happen? Very rarely. If we're in the situation of we're trying to force a resignation as opposed to the person voluntarily resigning, that's just not, luckily, something that just isn't.
I do think like adjudicated is, I'm assuming, refers to a judicial process rather than a competent tribunal, which is extremely vague. So I do prefer this wording, but yeah, I just wanted to get that relationship sorted. So thank you.
Absolutely. Thanks for the question. And Nathan, please.
Is an adjudicated incompetence always permanent or semi-permanent, or can someone be adjudicated incompetent for a week or a few days or a much smaller period?
So it's not going to be as temporary as a week or a few days, but you know, Kim mentioned an accident. You know, if somebody is incompetent as a result of a brain injury and then recovers, it doesn't have to be permanent, but it's not going to be you're incompetent today, you're competent tomorrow. It's not going to be that type of dramatic change.
Jason, please.
Yeah, I mean, on that I'm just from a medical standpoint, this is not the comment I was going to make, but you know, something that happens for a week or two where then someone becomes completely lucid and competent again, I don't think that's what we're talking about at all. I guess I want Shelby to confirm that. This is much more, you know, at some point, if you have a traumatic brain injury, you know, you go from it's a short-term thing to, wow, we're 3 months in and this person still can't feed themselves. Like that's a whole different story. Okay, so I wanted to ask about the competent tribunal. Is that just, Shelby, is that just language from 150 years ago? What is, like, that doesn't even sound like things we would say anymore. Like, what did it even mean?
Yeah,
what's going on?
So basically what it means, and it is just old language, but it's not totally, people still use that language. So if you look at like a real estate contract, which tends to use really old school language as well, a competent tribunal is basically a court with proper jurisdiction. And so it would be, is it a circuit court? Is it a bankruptcy court? Is it, which venue is appropriate for this specific action? So a competent tribunal just means the proper court. It sounds funny, but that is kind of lawyer speak for the proper court.
Thanks, Shelby. And Zachary, please.
So yeah, that makes a lot more sense now. I mean, I guess I don't really know the full scope of like what each, are we getting to the decision part kind of soon, or are we just gonna keep talking about?
I was gonna wait for the hands to drop, but I think most folks I've been hearing agree that adjudicated incompetence makes sense to include in the charter.
Yeah, I don't think we even really need a vote. I don't
We make the determination based on if there's any dissent. Does anyone disagree? Okay. Moving on. So this is currently in Tigard City Charter, I believe, and quite a few others. Something around the idea of it's the failure to qualify for office within X dates of time of the term beginning. So when we set those qualifications, whatever they are that have to do with residency, you have to submit some paperwork and prove that you meet the qualifications, and you have X number of days to do so if you have a provision like this in the charter. I think it's usually about 10 days to prove that you are a qualified elector and qualified to hold that office. Any comments or questions on this one? Jason, please.
I don't think this is really exactly how we've been doing this in Tigard. Carol can speak to this, but and part of what's confusing to me, even from the prior discussions, is that in practice, I think what happens is Carol, as the city elections official, goes to the county and verifies, like when she verifies your signature or verifies signatures to get on the ballot, she verifies that you're a Tigard registered voter, now that I think about it. Carol, you can confirm that, but I think that's what happens. And so this qualification, I know we then have to sign a paper accepting our, like the results of the election and sort of accepting that we're taking the role or something. I don't know what the right Carol words are for it, but I don't think in practice this is exactly how it's done right now.
Carol, please.
Okay, well, so when I meet with people running for office, we often will look at Tigard maps and make sure that they're in the city limits. It's kind of a waste of their time and effort and money if they don't live in Tigard. A lot of people don't know they're on the line. Maybe they're unincorporated, they don't realize it. So that actually gets done before they even, get started. They do have to, accept the nomination, accept that people have, they got the signatures that they needed. And then we also require them to give their oath. So I don't know if that would be included in this or not, but they do have an oath of office that they have to do before they can serve.
We do require the oath in another piece of the charter.
Okay, all right.
Kim, I have a follow-up on that from Carol.
Yeah, go ahead.
Carol, I thought you guys had us sign line 1 of our petition for purposes of checking with the elections official or the elections office. Am I wrong about that?
No, that's correct, because I don't have voting records. I can, ascertain your address is in the city, but the county would have to check that. So that, yeah, that's done when we take in the first signature pages.
Thanks. And John, please.
Yeah, to me, I don't see how this relates to how vacancies are created. To me, that's all how somebody takes office. So a vacancy means somebody's already taken office in my mind. And so from that standpoint, we have to sign everything, and she checks everything when you sign up in July or June or August. You have to sign the paper that says you accept the results of the election. Well, that's 2 to 3 weeks after November. So it's usually around Thanksgiving. So, I know in some of the other things we were talking about, some of the things we were reading were like within 8 days of January 1st or 10 days of January 1st. I don't see how that really comes into play here, but I know that that's the examples we've been given, but I don't see how that really happens. And maybe I'm just missing something.
Honestly, this might just be an oldie-timey thing that does not need to belong in our charter because that's not how we do the process anymore. Jason, I think you had a response to John. Go ahead, please.
Yeah, wouldn't that, I'm actually thinking through this. If someone didn't accept their nomination, wouldn't it go to the next highest vote getter if there was one who was not elected during that election?
Probably. I don't know that if that's ever happened, but
I think that means, like, to John's point, that wouldn't be a vacancy necessarily. It'd only become a vacancy if no one else ran.
All right, Tony, please.
I think along the lines of the ceasing to reside and kind of in that same spirit of failure to qualify after winning the election and absence from the city, it seems like the spirit of that is that at some point after they've been elected, that they cease to meet the criteria that they would have had to meet in order to take the office in the first place. And it seems like there might be a way to kind of say, like, ceasing to reside in the city or otherwise fail to meet the qualifications that are required for the office and failure to rectify it within X period of time, because there's some things that you might no longer, like, you wouldn't have been able to take that office if you were in a certain circumstance, but that might be a temporary situation for someone. Like if their house burnt down and they had to stay outside of the city, are we going to say that they're no longer allowed to be in the office because they're not residing in the city? Well, does that seem fair? Wouldn't we want it to be some sort of, day criteria for how long you cease to reside and get back in, something with that kind of language? Maybe there's an example of that.
Yeah, no, there's not, but it's a really great point that brings us back to, if you fail to qualify pretty much any of the examples that we've brought up, then you're failing to be a qualified elector in some other way, which makes this very repetitive, I think, to your point. And that it goes back to, what do we do about what makes a qualified elector? And again, looking at some of those examples about continuing to be a qualified elector, even in cases of emergency, that, like what you mentioned. So I'm hearing just generally that this does not need to be in our charter, but Zachary, feel free to change our minds.
So, yeah, I think it probably really shouldn't be in our charter, but what would be the X amount of days for the time of the term offices to begin, like failure to qualify for the office in X days? What would that be?
It's usually about 10 days.
10 days? Okay. So like if you were to not qualify for office within 10 days or something?
That would be how this is written, yes.
Okay. Yeah, that doesn't make any sense. So it makes sense to get rid of that. I don't know.
Does anyone feel strongly that we need to keep it? Okay. So now this actually the next one came up during our conversation about the council presidency. And how long of an absence does somebody, or basically what length of absence from duties creates a vacancy? So I think it was actually Zachary who asked this question about, well, what if there's a mayor and they just don't show up for 3 months and they assign the council president? Is there a limit? And that's what this would be. So either needing council approval or no absences for such a long period, usually around like 90 days. Jason, please.
I just want to clarify so I understand this. This is basically a provision that gets at someone who's essentially abandoned the role. Is that kind of what I'm getting out of this? Okay. I mean, I've never thought of this. This concept is kind of bizarre to me. So I'm sorry I'm asking dumb questions.
No, it's because you run for election. You know how weird it would be to abandon your role after running for the office. But yeah, this is essentially abandonment of the office. For if you abandon your duties for more than 90 days, you would no longer, a vacancy would be created. Margaret, please.
Well, I think there's just with what happened in the legislature with the measure, whatever the measure was about the 10 days, is that at least a precedent is being set on some sort of a level that if you don't do your job for X amount of time or whatever. And so I think it's something that needs to stay. I to be honest with you, can't think of something like this happening, but at least to be on the safe side, it might be something that we may want to keep in. And so somebody just says, I'm not showing up for meetings, forget it. Yeah.
Yeah, thanks, Margaret. Karen, please.
I was thinking some of the language kind of got dropped because it's absence from the city without notifying the council or without council permission or consent, I think. So it really is somebody walking away and not telling anybody anything. Because obviously if you had an illness and you asked permission to be away for 3 months, I think council would probably allow that with understanding and not deem your position vacant. But I do think that phrase needs to be there.
Thank you, Karen. And Zena, please.
So can it come under the recall from office, this requirement, like, or what is like recall from office is about?
Recall from office is if basically the public thinks that an elected official is just not doing the job that they want them to do, and then you can collect signatures and basically put the person up for election early, and then have the entire city vote whether or not to let them keep their office or to remove them and replace them with somebody else. So that's more of an elected, like, petition heavy thing, whereas this would be a bit more around abandonment.
Oh, okay.
Thanks, Zena. Great question. Dolly, please.
I think it's a good protective clause. And I'm with Margaret that maybe we should follow or look at what the state is doing and then just follow the number of days on what they're doing. That way, people who have ambition to go on state after their city service already know the rules.
We should look at what the state is doing. I will say there is a difference between being a state legislature and what the requirements are for like your day-to-day than what it is to be a Tigard city councilor.
But it would be a good basis though.
Yeah, state legislatures are just full-time, whereas our city council are part-time positions. Margaret's laughing at me, I think.
No, I think what it is it's just the idea that a precedence is being set, and I think it's in lots of other areas, that if you just don't show up for work, then there are consequences. And I think that's what this means. And so if I go through and I say, look, I'm going to have surgery and I'm going to be out for 2 months and go to the city council, they're going to do that. But if I just don't show up and don't talk to anybody and don't do whatever, I think that definitely is grounds for removing somebody that would create a vacancy. But the state's a little different situation. But I'm glad Dolly brought it up because it's just maybe something we can look at, just saying it is being done someplace in the state of Oregon.
Yeah.
So thanks.
Great reference. Thank you. And I'm going to we haven't heard from Jeanette yet this evening, so please.
Oh, I think I spoke once before, but thank you, Kim. I actually concur with Karen that it's vital to have it without council consent. And it's nonpartisan, so hopefully we don't get into the state issues of partisanship. Would kind of be a second comment. And then third, has this ever been an issue? Not saying it couldn't in the future, but just for historical perspectives, has this ever been an issue in Tigard?
Don't think so. Zachary, please.
I just really think that it is important to get council consent. And so, I mean, if we don't want any like big walkouts, you know, because someone doesn't want something to get passed, and I think that it will get passed if they're there. Like, you know, it happens to the state legislature sometimes or federal.
Thanks, Zachary. And Tony, please.
Yeah, actually, I feel now maybe it's not something that can happen at this specific level, but I actually feel pretty strongly in the opposite direction, is that if the only means that someone has to kind of make their voice heard is to go on strike, I don't think that we should be removing them from office, because that's the only mechanism they have. If they don't have the votes to keep their position in there, I mean, that they can be recalled if they're not doing their job. But having the politics of the rules remove someone that feels strongly for their position, that they are willing to go on strike or you know, be absent. Obviously, you're not going to get permission from the council if you're going on strike as a council person against the council. So I kind of feel like taking that mechanism away, because that is politically neutral. Anybody from any political party or affiliation can say, I feel so strongly about this circumstance that I need to step away or I need to go on strike. That's kind of taking that away through rules. To me, I have a little bit of a problem with that.
Thanks, Tony. And Jason, please.
I guess I would just share, as we're thinking through the changes we're making, to Tony's comment. You know, currently all you need is a majority of the council that are present to pass something. There is nothing that requires a quorum at a meeting currently. And we haven't really talked about that, but the effect of someone not showing up, unless in the current council there were fewer than 3, I guess. Shelby, I'd be curious to hear your comment about this. It'd be fewer than 3. You'd need 3 people to show up to pass something, because then you'd have a majority, and then the new process, or the larger council, I think, would be the same thing, right? You just need a majority of those present at a meeting to pass and conduct business.
So state law requires both a quorum and a majority. And so there needs to be, right now, there needs to be 3 members of the council to conduct business, and a majority of council is 3 members. And so you would need a unanimous vote of those 3 members right now to pass anything. So
I don't think we've followed that. I'll just be honest with you.
We definitely have.
We have? Okay.
And quorum is written into our charter. I did just check.
Okay, and quorum being 3 currently?
Mm-hmm.
Yep.
And it would become 4 with the proposed changes?
Yes.
Okay. I mean, I guess with the number being so small, that's just never exactly come up in that way. So maybe that's why but I think we've passed things with 3 votes, or with 3 people present. And anyway, okay. I'm just wanting to make sure we're thinking through all that.
Yeah, so like actually the emergency ban on fireworks that we did in 2020 was, we had 3 members present, and there were a couple 2-1 votes that didn't pass. And then we finally got to a 3-0 vote. So, yep.
Thanks for reminding me of that. I remember that. It was kind of traumatic.
It was.
So given that we now live in this virtual world where absence from the city doesn't mean what it used to mean, I would like to propose, based on the feedback that we've heard from this group so far, that maybe the question is, from all council meetings within an X day period without council consent. would be the language that would be added to the charter. I'd love to hear feedback. And John, please.
Yeah, I'm okay with that. I want to comment. I agree with what Tony said, but the difference is, it's back to the quorum point that we just talked about, is if we currently have 5 counselors. If 3 of them decide they don't want something to happen and therefore don't show up at a meeting, number one, they don't have quorum, therefore they can't have the meeting. And if they did all 3 show up at the meeting, they would win the vote 3-2. So from that standpoint, it's really different than what's happening in the state. And so I don't see it being the same way. And so I think their vote can be enough to, I don't see how it can happen the same way as it can in the state level, because their vote themselves can make it work because of quorum. So, but I'm fine with keeping the second half, and I like the 90 days versus like 30 or 10 meetings or something.
90 days is a good period.
So another just clarification. So since we're talking about the state, so the state requirement is not that the legislators who miss 10 days are expelled. The state requirement is that they are unable to run for re-election. And so not apples to apples when we're talking about that here. And also we fully expect the constitutionality of that constitutional provision to be challenged. So I don't know what that case will end up looking like. I don't know what the decision will look like. So this is if we did go this direction, this is an untested direction.
Any other comments? Okay, so the question is, does the committee recommend that absence from all council meetings within a 90-day period without council consent create a vacancy? A yes would say, yes, I recommend that this would create a vacancy. No is I do not recommend that this would create a vacancy. Does anyone care to make a motion? Zachary, do you call the question? Is there a second?
Second.
Any comments? Derek, please.
Is this without any sort of permissible excuse, or what? Just, I don't know if we clarified that point.
It is without council consent. So it's not laying out what excuses would be permissible, but it does allow for someone to get the consent of council in order to be absent.
Is it required that they get the consent of council, or can they just advise that they're not going to be there, or is that something that would be determined in the rules of council?
It would be determined, and under this, if they just advised that they weren't going to be there and they didn't have the consent of council, then they would be creating a vacancy and basically abandoning their duties after 90 days. John, please.
Yeah, I have trouble with, Derek had a great question. That's a good point, is if the council didn't give them the consent, to me, it's notice that they're going to be gone, and maybe reasonable reason they did it. But the reason I'll probably vote no is the point that Shelby just said, is if this can be contested by, it's going to be taken to court because it might not be legal. I'm not happy about putting it in.
Fair. Jeanette, please.
Yeah, thank you. Actually, Derek had my question, and I concur with John. So no question.
Okay. And Tony.
Thanks. I appreciate kind of informing that in this circumstance, my thought process is kind of moot, because if you have a majority, that's what it takes to stop it in the first place. And then if you didn't like what was going on, you'd just be able to win. So there wouldn't be a reason to strike, because you have majority. So I appreciate that. But I do have a question along those lines of consent. Could this run afoul of something like Americans with Disability Act or something, if someone wasn't given consent by the council, but for instance, if they had a medical reason or a religious reason or something that is a protected status in this context, would not having some sort of language that allows for that to kind of address the difference between consent and what is already a protected legal concern, because we don't really want to give people a kind of a mechanism or create an environment where they're likely to be a lawsuit, because those are really expensive for cities.
Yeah, I mean, I'm thinking of Dianne Feinstein, where she's basically said, I am not able to come sit on committee. And there's a lot of controversy around that, and a lot of controversy about, is that a vacancy? And has she been out long enough that she needs to come back, or is she going to recover? So yeah, I think I don't have a good solid answer for you. I think it is an ambiguous situation.
And Zachary, please.
I mean, I think there's a lot of arguments on both sides, and it's really interesting to think about because, obviously, if you want to go on strike, you don't want to have legal repercussions for, protesting something that's happening. But then again, upholding the whole normalcy with the law is also important. So I don't really know. I guess we'll just have to see how other people vote.
Thanks, Zachary. And Lindsay, please.
Can I move to change it to, instead of council's consent, to notify council? Because I feel like the issue is that if you're away from your post for 90 days and you haven't said anything to council, no one knows where you are, if you're dead or alive or what's going on. Like, that's really the issue. There are situations where maybe you would have to be away, and it doesn't mean that you can't still hold your position as elected official. But I think the issue is really like just not letting council know what's going on. So maybe it's less a consent and more just communication. So changing it to notify.
Yeah, and my Robert's rules is not great. So is there a second to changing this from without council consent to without council notification?
Well, it would be an amendment, and that amendment would be voted on first. But back to your Robert's rules, but I would second that amendment.
Okay. So comments about the amendment? Margaret, please.
Oh, no, this isn't about the amendment. I'll go back to the main measure.
Yeah, I've got you. And then Jason? Yeah,
on the amendment, I sure would like to see it have to be some sort of a bona fide reason. Like the idea that I'm in Australia, see ya. Like, I don't think that passes muster. So I'm just commenting on the amendment that I think it'd be maybe an amendment with a little bit more teeth might be helpful, or specification. I mean, it's one thing if someone has a medical condition or something else, but just like saying, see ya, I'm going to be in Europe, I don't find acceptable.
So we're going to vote on Carol, please.
Yeah, I agree with Mayor Snyder. I don't want to hear from somebody that, I'm going to be gone for a while. I'm letting you know.
Just to kind of dial this back to from the outside, like cases that are unlikely to happen to what is most likely to occur. I think we're catastrophizing maybe a little bit in this group about scenarios that are extremely unlikely. So just want to recognize that in this room. It could happen. It absolutely could. It's just, yes, Lindsay, please.
I guess the question is then, if someone is just like, I need to go to Australia and just be by myself for, 3 months, like, does that come out of like the oath of office? Like, is there another way that cross-checks it? So by taking your oath of office, you're, taking on that, like, is there another way that it gets at someone who just doesn't want to do their job anymore? And they're notifying council, but they would still have a vacancy because they're either adjudicated incompetence or I don't know, is that part of the oath? I don't actually know what the oath is that they take.
No.
It's
covered there.
Yeah,
Okay.
the oath is you're going to follow follow the rules, the Constitution, the laws of the City of Tigard and the State of Oregon, and perform your duties to the best of your ability in the office to which you've been elected.
Thanks, Carol. Zachary, please.
Well, I mean, obviously there's the case where, you know, you're just like, see ya, I want to take a vacation. But then again, like, I don't think you'd be fully protected, right? If council still wanted to evict you for that behavior, right? Because they could vote on it and be like, hey, that's not right, type of thing.
Thanks, Zachary. And Tony, please.
So I kind of changed from opposition to support for this, but then the logistics of it are kind of a little bit frightening. So my question is for Shelby, is there any sort of kind of standardized language or a legal reference or something that can be made that kind of gives us that definition of what a bona fide reason would be to be absent, so it's not subjective to council consent or something like that? So something that is already well defined as a bona fide legal reason for somebody to be absent from the office.
No, there's really not. I mean, it's kind of like, is there a reason to be absent from work? You know, I could have it could be the weirdest, most random excuse that the world has ever heard of, but it's legitimate to me. And so it's the one and only time that excuse has ever been used, but that still makes it a legitimate reason. So no, unfortunately, I mean, illness, death of a family member, you know, there are the obvious ones, but people have interesting lives and there's really no standard.
I think we're kind of getting to the point of why this is so vague in all the other charters is because this is very, very difficult to get to list out all of the reasons why someone might legitimately take a significant break. One thing to think about is to lengthen the number of days. So if you are thinking about the legitimacy or illegitimacy, if you think, well, 180 days is just unacceptable no matter what the reason, versus a 90-day absence. Jeanette, please.
I'm not sure where we are in procedures, but maybe.
We're gonna start over. We're just starting over.
I guess the question is, if this hasn't happened in 61 years, are we really that concerned it's going to happen? And do we really need to name it? It would be my question. And given that, I would say I would not include it.
Thank you. And Margaret, please.
Okay, and I would, two things. I think that the council does need to have some ability to, you know, they need to be informed and all that kind of stuff. And so with the amendment, I would vote no on that. But I think that of anything, it is to put down in writing, you know, person that's running, this is our expectation. And if you don't meet these expectations, these are the consequences that you will face. And I think just being transparent and open is the most reasonable reason, or a good reason to keep this in. So.
Thanks, Margaret. And Tony.
Maybe kind of to speak to the responsibilities of the council, and we would hope that they would have kind of the best interest of the community and of their fellow council people in mind. Is there a way that we could amend it to say something like 90 days and then council would have the authority to vote to recall or remove the person? So that way you're gone for 90 days, or we could even make it, you know, 45 days or something. That way, if council knows that this person isn't going to be able to come back, or there's not a legitimate reason for them to be gone, then there's kind of that double, you know, protection there. Because if someone is going to be gone for an amount of time that we think that should qualify as a vacancy, but council feels like that there's a legitimate reason, then we could trust the council to have the community's best interest at heart. And if that's not the case, you know, that it isn't a valid reason, then they could actually expedite the process of creating that vacancy.
Thanks, Tony. And Karen, please.
I like Margaret's suggestion to put something into into the rules for expectations, kind of like any other behavior. But I feel like where this is going a little bit is the distinction that like Beaverton made. They listed things that the council votes on to deem a vacancy versus our section 32 is just an office is deemed vacant. So I'm just wondering if we're getting somewhere where some things we just want it to be automatic and some things we want it to be voted on. And I don't know the answer to that, but I just can't help but wonder if there are two different ways.
Yeah, no, that's a good point. So it's actually the LOC version, and they have it upon declaration by the council after the incumbent's absence from the city for 30 days without consent or from all council meetings within a 60-day period. So that's where it gets at, I think what Tony was even talking towards of, okay, once you've been absent for this, then the council may declare your seat vacant.
Yeah.
So I guess there's this, before we did spend too much more time digging into all these details, there is just a big difference, I think, right now in should there be even any sort of clause in the charter that gets at this issue, of abandonment, or is this suitably covered by other things like recall or other options, failing to reside in the city? And so that is a question that we could call. And I'm kind of interested in, okay, so let's go really top level. Does the committee recommend a vacancy be created by some level of abandoning the position? Okay. Before we get into the Roberts rules and I have to undo everything again, is there any questions, changes, amendments to this? And John, please.
Yeah, Shelby, does that still pass the muster, or would that still be litigated?
Yeah, I mean, the issue is around, can anybody other than the public who elected an official remove that official? So we did opt to, in the no interference clause, we do have the removal from office there. So we did decide that that was an acceptable risk there. But yeah, anytime it's somebody other than the electors removing the person, that hasn't been tested. And then the vacancy as the justification, that will be part of the constitutional challenge made by the legislators.
Shelby? Does anyone want to call this question?
I call the question.
Is there a second?
A second.
So yes says recommend some level of abandonment. We'll continue this conversation. No vote says no, I don't want to see this in the charter at all. And if there's, depending on where we end up, we may move on. Carol Krager.
No.
Derek Lawson.
No.
Jason Snyder.
I was going to vote yes till I heard Carol vote no, and I'm very partial to Carol's opinion on these things. So I'm concerned. I'm confused by my own thoughts. So I'll abstain.
And Jeanette.
No.
John Cook.
No.
Karen Emerson.
It won't matter, but I'll say yes.
Lindsay Murphy.
Yes.
Margaret Doherty.
Yes.
Nathan Jackson.
Yes.
Tony Simpson.
Gosh, I'm right smack in the middle. I will say no because of the potential for litigation.
And Zachary Claremont.
No.
With a vote of 4 to 6 to 1, the group has failed to reach consensus. I don't think that we're coming to a conclusion on this one. And so we are going to default to what is currently in the Tigard City Charter on this, which would be upon his or her absence from the city for 30 days without consent, or upon absence from regular meetings, and upon declaration by council of a vacancy. So council would be able to declare vacancy, and absence from the city for 30 days without consent of council would create that vacancy. John, please.
Yeah, I didn't know. I know the rules, and if we don't pass something, we fall back. But you know, quite a few people felt voting. The reason they voted no was the litigation factor, and the fact that this is still in our charter and it has a litigation factor. I still have an issue with that. So I don't know if we can get to 8 votes of removing this from that, but that would be my worry.
Yeah, that's a good point. And Lindsay, please.
Just with the litigation factor, because of what Shelby said, I get that, but this is also going to the voters. So the voters are also approving the charter. So in a way, indirectly, of course, you know, they are supporting how this happens. So if a city council member is removed this way rather than through the public vote, they did kind of approve it in a way by approving the charter. So that, I think, is just like food for thought, because we really don't know how this is going to turn out in court.
Yeah, so ultimately the decision would be based on how strong home rule authority is in Oregon. The judge would have to decide if this is appropriate for home rule, or if this is beyond what home rule grants a city and essentially interferes with the rights of the voters. So my concern with this language is absence from the city for 30 days without consent, because in the era of virtual meetings and travel, remote work, it could be very easy for a counselor to attend every single engagement that they need to virtually and be gone for more than 30 days. So if I were to advocate for it, at least part of it to be taken out, that would be my biggest concern, is just that I think that's not reasonable. And as we discussed earlier, how do we prove absence? Is the counselor going to notify us that they're working remotely from Washington because of an ill family member? And is that a disqualifying event? So I think this language right now is problematic, though obviously it has lasted us for this long and hasn't been an issue. So
Jeanette, please.
Yeah, I would concur with Shelby. You know, upon COVID, there's many times where you could be, and I don't even know how we define from the city, but you can be virtual. And I'm one of those who, due to my day job, I could be somewhere for 2 weeks. And matter of fact, I was in the country of Norway and managed to make 2 of the meetings. So and I'm sure there's many other counselors, potential counselors, who could be in the same position with aging parents or sick children. So this wasn't taking into account our era of digital Zoomness. And so maybe we just change from the city as a consideration. Thank you.
Thank you. And Tony, please.
Yes, that's kind of my concern too. I'm, as much as I kind of switched to supporting it, I kind of feel like it might be wise to consider striking it or changing it, the definition of absent, kind of to Jeanette's point. If someone is forced to quarantine out of state or out of country, they can still, I mean, there's no reason why any of us could not be not in the city right now. We're all on a Zoom call. So are we failing to perform our duties? No, this is how we meet. So that you know, especially it being 30 days, because you could very easily be forced to quarantine or be restricted from travel. Numerous people were stuck on cruise ships for more than 30 days. So if you're attending your council meetings and you're doing all of your work remotely, you know, granted, the thing I do like about this is this does have some control from the council, that it's the consent of the council that's making this determination, which I really appreciate that. So I don't know if Shelby or someone wants to kind of chime in on that, how that consent of council, how that control measure plays into this, but I definitely would have a problem with someone being removed from office if they were doing all of their work just because of an arbitrary timeline.
Thanks, Tony.
Yeah. So to address that, I do think that the declaration of council of the vacancy, I do think that that's helpful, because that's one more checkpoint on how realistic is this? Is this a situation where the person has just up and walked away and we have no idea where they went and they left a note that said, bye, you know, some to our our far-fetched hypotheticals from earlier. It gives the opportunity to revisit based on all of the facts that we don't know right now when we're coming up with hypotheticals, what is realistic or what is not. So I do think, I can't say that it's a guarantee that that will save this provision and make it constitutional and legal, but I do think that it's better because it's one more chance to revisit it in light of everything that we don't know right now.
Thanks, Shelby. So something to consider is just removing that first sentence and then leaving the charter kind of alone for the second. So Carol, please.
Yeah, and I was thinking that absence from the city means that you've just abandoned, rather, you know, if people are participating remotely, they're participating, they're still involved. So maybe we need to clarify that.
Yeah. And we do talk about absence from regular meetings. It's in that second sentence. So maybe it's a little more specific than absence from the city. And John, please.
Yeah, I think, well, first of all, the his or her should be there maybe, because back onto our other issues. But, you know, I agree. The next point talks about regular council meetings. To me, if it said something like their absence from city meetings, or, you know, because there's city council meetings, there's, you know, you've got liaison meetings, you've got other meetings if it said some kind of city meetings for 90 days, I think it would be a lot easier.
Thanks, John. Nathan, please.
I'm not sure what my comment is. I guess I'm just a little lost because I thought we voted and most people said they didn't want any sort of enforcement of abandonment of the position.
Yes, so
why are we still?
So we go from committee discussion to concept consensus, and we need 75% of folks to agree on whatever the concept is. If there is agreement, then we go to the city attorney drafting it, if it's something that needs drafting, or it just becomes the committee recommendation. So if the committee recommended to strike, then the city attorney doesn't need to draft it, we can just strike it. However, we did not get 75% on that vote. It was 4 to 6 to 1. So we are at no recommendation, which means we default to what the charter currently says, because this is a little convoluted sometimes, but most of the time it works just fine. Does that clarify why we're still talking about it?
I think so, but it just seems a little, it just feels like we're going in circles a little bit.
We absolutely are. And I'm going to say we've got probably 10 more minutes left on this topic at most. And then we are going to default to what the charter is and move along to our next topic. And then we can come back to this later, but there really doesn't seem to be a lot of agreement. So I'd love to have questions called or yeah. Tony, please.
And I definitely don't mean to dismiss the no inclusion of this type of language. But in that sentence, for me, switching that last or to and, so that it's a sequence of all of these criteria must be met. To me, I think that makes it a lot fairer and stronger, and also, you know, changing the his or hers to their is reasonable. But I think that without the consent of the council and absence from regular meetings, because that addresses the attendance via remote. You're actually attending the meetings. If it's an or, then that's not a, you know, an all-inclusive. But if we move that last or to you know, where it says council or upon his or her absence from regular meetings, if that was an and, to me, that would, if I had one change, that would be my 10 cents. I hope that is useful.
Thanks, Tony. And Jason, we haven't heard from you in a minute. Please.
I'm going to make a suggestion that I don't think we're going to get there. I think we've had a robust discussion. I think we've thought of a lot of problems and situations. And I think this is one that we should actually punt to the current council to figure out. I think we should tell them what our discussion was, what we're concerned about, and recommend that they actually have a solution, but we don't know what the solution exactly is. That's my recommendation.
That's a great suggestion. Thank you, Jason. And actually, how do folks feel about, so there, I guess let's talk about kind of what happens next anyway. So when these recommendations are done, when we've completed our work here, we're going to go to council and present a one-pager and talk through, these are all of our recommendations. This committee's done a great deal of work. I invite you all to come to that council meeting and speak to the work that you've done. And then we're going to take all of that body of recommendations and go to the public and talk to the public, and who are going to be voting on this later, about these are all of the recommendations that have come through, and these are all the things. Give us your feedback. Is there anything that rings really true? Is there anything that you're opposed to, etc.? Bring all of that back to council with both sets of feedback, being like, this is what the council, this is all the recommendations that this committee did. We did this over 8 months. Here is some community feedback, and ask council then to recommend what is going to go into the ballot. So all of that together is how this process is going to go. So by kind of asking council that this is an area where we'd like your feedback, would be just part of that process. So how do folks feel about, had a great discussion on this today. Probably isn't going to get decided tonight, and we do have a lot of other decisions that we can make. So holding this and asking council to have an opinion or make that decision later. Does that sound good to folks? Okay. Great. So that one can go highlighted in yellow. So this is one that is in Tigard's current city or current charter. Unlawful. Let me just double check that before I say something that's untrue. Yes, unlawful destruction of public records is in Tigard City Charter. So it is also covered, I believe, by just law, but it is in Tigard City Charter. So if folks feel strongly about including it or not including it, I'm seeing John shake his head, happy to strike it. It's covered in a lot of other places.
What does that mean?
It means going to the paper shredder with all that stuff that you shouldn't be going to the paper shredder with, or trying to delete documents off of your computer that you shouldn't be deleting documents of.
Okay.
Yeah. Lindsay, please.
Yeah, I would say if it's covered elsewhere, we take it out, because it's also very specific to just destruction, instead of like, you know, hiding or hoarding or moving or other unlawful things that you might do with public records. So I think it's a little too specific and repetitive.
Makes sense. Does anyone feel strongly about keeping it? Carol, please.
Well, I think destruction is too limited. And so if we're saying elsewhere that they need to follow public record law, then I'm happy with that.
Yes, and we do have language about public records law referring to the state laws.
Yeah.
Anyone opposed to striking this provision? Okay, now we get into the one that I thought was going to be the most time consuming and fun, but maybe not. So there are several places in charters where if you commit a crime that may create a vacancy, and different charters treat it differently. Some say conviction of a misdemeanor, some say conviction of a felony, Some say conviction of a crime leading to loss of liberty. So if you have a jail or prison sentence as part of your conviction, and then a lot of charters leave this completely blank. Would love to hear your thoughts. Tony, please.
When I look at that, I kind of think conviction of a crime leading to a loss of liberty is sufficient. The type of crime and whether it's a misdemeanor or a felony is kind of moot to me, because that kind of is then that creating a, you know, in an absence from the city for X days. If you're a conviction of a crime that leads to a loss of liberty, so you're not able to perform your duties, and having city council voting from jail by their one phone call or whatever, to me isn't really a good look for a city council person. So I kind of think just saying if you have lost your liberty, maybe you shouldn't be in office anymore.
Thanks, Tony. Karen, please.
For me, this one gets into the qualified elector part, because if you are in jail, you've lost your, at least presently, you've lost your right to vote. So as of right now, it's a little bit redundant. Could change. But that's what came up for me.
I think if you are convicted of a misdemeanor, though, you do not lose your right to vote.
No, I was the loss of liberty, but you're right. Misdemeanor would be different.
Would be different. But yeah, excellent point. Thank you, Karen. And Zachary, please.
I mean, if I'm be honest with council, I mean, I'm a good driver and stuff, but I feel like a lot of people, you know, if they got a speeding ticket and then they like got in trouble with council, that'd be really, really annoying and probably embarrassing too. And they had to, you know, they couldn't really be around anymore because they just got like a, you know, speed radar vans, you know, they have now if you're going just 6 over. Yeah.
I don't think a traffic ticket qualifies as a misdemeanor, though I could be wrong, and I'll punt that to our attorney, but there are a lot of small infractions that would be misdemeanors. And Zena, please.
No, I was thinking something what Karen asked. So this loss, crime or something, it should be coming under qualified, like ceasing to be a qualified elector.
Yeah, and I think Karen made a great point. I think felonies and crimes leading to loss of liberty take away your right to vote, at least for a period. Margaret, please.
And actually, I would like to keep the language in where it is, because sometimes a misdemeanor, the way that the law reads it, it's not more than, you know, jaywalking or something. But I think what it is it's the integrity of the council and the integrity of Tigard government to have people that are kind of on the up and up. So I would think we just keep that in.
So this
because
is
what it is. It's if you look at the language, it's conviction of a misdemeanor. Not that you've got a misdemeanor, but you have to be convicted of it. So
just to clarify, none of this is currently in the Tigard City
Charter. Yeah, but I think that it would be good to have it in there.
Thanks, Margaret. And Jason, please.
I was just going to help clarify some of Zachary's comments about the, you know, traffic infractions are mostly what you were just describing. There are 6 traffic crimes, or there used to be when I was a police officer. And those are things like DUI, things like careless driving, reckless driving. Those are all crimes, and some of them have felony and misdemeanor things, but that's not the typical scenario. To be convicted of those requires a lot more stuff than just speeding.
Thank you, Jason. And Karen, please.
I just wanted to point, our current charter does say conviction of a felony creates a vacancy.
Oh, yeah, right. It does. Absolutely. I'm so sorry. I missed that.
But I'm also wondering, because it would be different, and it is in Beaverton's, is where it says other offense pertaining to the office, which I think would include ethics violations. And so I guess I'm intrigued that that didn't make your possible list.
I see Beaverton. I don't see that on Beaverton. Death, resignation, recall, ceasing to reside, ceasing to be qualified, removal from office.
Oh, I think I'm looking in the removal from office where,
So they got LOC, death, adjudication, recall.
because removal from office B has violated any applicable rule of governmental ethics. But maybe that's that discussion of what's deemed a vacancy versus what's voted on to be a vacancy.
Oh yeah, I missed something in Beaverton. Thank you. So what I'm hearing is generally folks feel positively about keeping some form of this in the charter. Right now, felony is what is currently in the charter, although that would also disqualify someone from being a qualified elector as well, so it may be redundant. John, please. Oh, you're muted, John.
I was gonna say that the loss of liberty is where I would agree if we would change the felony to that. But at the same time, it's redundant to me, so I see no reason to have it because it ceases to be qualified elector. So I don't think putting it back in again makes sense.
And you don't see value in changing it to conviction of a misdemeanor?
No, not at all.
Okay, thanks, John. Tony, please.
I appreciated Margaret's input. So the current language mentions conviction of a felony. So I guess my question would kind of be for her, because I think we're kind of on the same wavelength for the reasoning behind what we feel about this topic. So I guess my question would be, does she feel like the current language is sufficient, or if we might need to add some sort of additional conditions about misdemeanors, or maybe specific types of convictions? Since loss of liberty, it sounds like points back to qualified elector, and that's already covered, and I understand that there's a resistance to redundance. So maybe something that is not redundant, but it addresses that quality of character kind of question.
Thanks, Tony. And Nathan, please.
So I was just going to say, as far as giving you some more input on reading the room, just that I fall more into the camp of feeling like it's redundant.
Thanks, Nathan.
So just to address Karen's point, I did pull up the Beaverton Charter, and it is in the section of removal. So what council can vote on to remove a member of its own council, it's not part of the vacancy. So they blend together, but that's how Beaverton addressed it, as something the council could vote on to remove a member.
Okay.
I forgot they even had that. So I'm hearing some folks who like having it because it talks to the ethics and the being what it means to be a leader in the city. And then a lot of folks who find misdemeanors maybe a little too penalizing, and then felony to be redundant. Margaret, please.
And so what you're saying is that the felony part's already in the chart, already in some sort of charter.
The felony is currently in the charter, but it would also be redundant because you would no longer be a qualified elector if you were convicted of a felony.
At this point.
At this point in time, yes.
Because there is a movement to have felons people in prison be able to vote. So, yeah. But anyway, I mean, if it's already there and whatever it can, I mean, to me, it's kind of a no-brainer of just saying, you know, you're not going to be on the council if you are a convicted felon that has not been rehabilitated. But if it's, you know, it's not something I'll fall on the knife for. So.
So as a fun fact, the Tiger guy is now the third person in history to run for president from federal prison. So that is not a requirement for the US president.
I was gonna say for US president, you can be a convicted felon. Yes.
Yeah.
And
Yes,
do know-
and you can run from prison.
yes, you can. And they have run.
Great. Does anyone feel strongly about removing the current provision in the charter that says conviction of a felony creates a vacancy?
No.
No. So we're good on keeping that? Okay.
Yep.
Conviction of a felony. All right, and moving on. So how we fill vacancies. So there's two key questions, and then I'm gonna go through a couple examples, and then we'll come back to these questions, but I just wanted to put these out there so they're on your mind. One, does the committee recommend delegating decision-making on how to fill a vacancy on council, which is how it currently is done? So council, according to our current charter, council currently makes a determination on how to fill a vacancy. Or does the committee recommend a specific method for filling vacancies? And then there's kind of two paths that you can take. If the committee recommends a specific method, that method can be appointment to fulfill the term. So appointing, doesn't matter how long the term is left on the term, but appointing someone to fulfill the duration, or appointment to fulfill a period of time and then an election at the next possible date. So still with an appointment, but for probably a much shorter period, and then election at the next possible date. And those are the two questions. Margaret, please.
The one question I have on number one is, and I don't mind if the council, comes up with this, but I would assume that they cannot go through and say, okay, our method is that we're going to appoint somebody for the next 5 years. I mean, they can't go through and violate term limits, correct?
No, they can't violate term limits. They can only appoint someone to finish up the term that exists. So they can't even appoint, if there's 3.5 years left on the term, for example, right. They can't appoint someone to a 4-year term. There's only 3.5 years left.
Yeah, they just can't go through over and above that. Okay. Yep.
So let's look at Tigard. And again, the bold words are mine. So in the event that a mayor councilor becomes vacant before the normal expiration of the term, a special election may be held. And that's one of those keywords, is that may at the next available date. Such election shall, then the second provision says that you don't need to hold election. You won't hold an election if it's less than 12 months. So less than 1 year remaining on that term, you will appoint if it's less than 1 year with no election. And then you'll hold that election in accordance with the election laws. And then it says the council may appoint a person to fill a vacancy until an election can be held. So in this case, you could just leave that position vacant until the next election. But it does give council quite a bit of discretion, both on whether or not to appoint for the remainder of the term or to hold a special election, or to appoint someone to fill the vacancy until the next election can be held. And John, please.
Yeah, I like the way it's worded now. It actually was changed years ago to give the council more leeway in appointing or having an election. We've done both. You look at the last 61 years, we've had elections, we've had appointments. I think it's worked well. I think there's times when, you look at the time when I ran, the council decided, well, 2 of us want to run, and therefore, maybe it's better if we let the public decide or something. It's the kind of thing that I think that people can read the tea leaves and make the right decision. Somebody could say that somebody could take, I've heard comments earlier in some of the other meetings that, it's a good old boys club or something. I don't think it's ever happened that way. I'm not saying it can't, I'm saying it hasn't. So I'm back into the trying to create some hole of something that rabbit hole we're going to run down that really hasn't happened before. So I think it's worked well. I think having the variability, and probably a bad word, it has served the council well over the last 60 years.
Thanks, John. And Carol,
flexibility is the word John meant. Flexibility.
Exactly, and that's the word I was going to say. I think I agree. I think it's worked well. I like having that flexibility. I like having. I don't want to. It just depends on what's going on. How many people might be interested? It's just. I don't think that it leads to them, putting in their friends or anything like that. Um, they put a lot of thought into which way to go. I've seen that. And I like leaving that up to them for these short-term vacancies.
Thanks, Carol. Zachary, I do see your hand, but I do have a couple more slides before we get into the comment period, and then we'll keep going. I know it's okay, John. So how vacancies are filled in Beaverton. So this is a different example. This does not leave any discretion whatsoever to the council. It says that if there is 1 year or less remaining on the term, then the council will appoint for that position. If there is more than 1 year remaining on the term, then council will appoint for a period of time until the next election can be held. And that election cannot be held more than 120 days after that vacancy is created. So it puts a lot of structure around what the council must do, and it does prescribe an election in most cases. And then in LOC, handled it differently, again, prescribes exactly what the council must do, but it says will be filled by appointment for the by the council for the remainder of the term. So we have the Tigard example, which gives quite a bit of discretion and flexibility to the council. I think we've talked about already, there's a lot of different reasons why a vacancy might occur, and that may also influence how you may want to fill that vacancy. Beaverton is very prescriptive, but prescribes towards an election, and the LOC model is also prescriptive and prescribes towards an appointment. Which goes back to these two key questions of delegating that decision-making to the council for how to fill vacancies as is current practice, or recommending a specific method, and then if you want to recommend a specific method, what that method would be. And I would love to hear other comments. So Zachary, you had your hand up, so you can go first.
Well, yeah, I mean, I don't know. I kind of forgot it a bit, but I was gonna say, yeah. Okay, so I got it back again. So I was gonna say I like the way it's worded now, because I mean, I guess it does make sense to do it on discretion based on the choices, because you wouldn't want to appoint someone you're not 100% sure would be a good fit for the council. See,
Zachary and Tony, please.
I agree. I like the inclusion of the may language, because Lake Oswego's is will, and I could see a circumstance where if there was a death or there was a catastrophe or something similar to the COVID environment, the council may just say, we've got other things to worry about right now. We can look at appointing somebody if that makes sense, 2 weeks from now, a month from now, at the next election cycle. I just think that this leeway is kind of important for this specific little issue.
Thanks, Tony. And Derek, please.
I was wondering if John or Jason or Jeanette could opine further on why the council might select to have a special election over simply appoint, what circumstances would arise where they might choose one over the other.
Jason and then John.
So, I think it does depend on things that people were already talking about, like how did the vacancy get made? I think the other components that go into it are what is really needed in this moment? Is there, either a stability or a issue or a need for expertise in a certain space, or like John described when the vacancy was created by former Mayor Dirksen, and both John Cook and Nick Wilson ran against each other. The conclusion was there's enough time for an election. There are reasonable people in the community that want to do the job, and there's no rationale to appoint for it. And then you've also heard us talk about situations where we had 2 mayors in a row die in office, and that was both traumatic for the community and also could have been destabilizing depending on how it was handled. So I think it's just a combination of a lot of factors that are kind of hard to sort of nail down altogether, but those are the kinds of things that we thought about, or I thought about as we were having these discussions. I'm curious to hear what John has to add.
I think I agree with a lot of what Jason says. I think the key thing is, in my mind, if I'm a counselor, it's really different if it's the mayor or if it's another counselor. But I can tell you, the 2 times the mayor died, the council appointed both times. When mayors have resigned, they've had elections. That's just what's happened. I'm not telling you that's one reason or another. I'm just telling you history, because I guess that's my role. I think that in times where we've had a counselor leave, they've usually appointed, if it's a short period of time, and if it's a long period of time, they've actually put it up for an election. So they've had both. And so it sort of comes into what the time, and that I think goes back to what you were just talking about. If the council feels that they don't have time to deal with it, let their electorate deal with it. If they feel that they want to interview and see who fits in best, and they have a spot they feel is needed because that person that left, maybe was a planning commissioner, maybe they had, other backgrounds that was, important, then sometimes that appointing makes sense to try and fill the need of that council, council cohesiveness. So I think the advantage of leaving it the way it is we've had both happen at all times. And I haven't heard anybody say they've taken advantage of it over those years of appointing their friend or something. Nick Wilson was appointed multiple times. Brian Moore was appointed. There were multiple people appointed, and nobody would ever say they were a bad choice for the council. Heidi was appointed. So.
Thanks, John. And Jeanette, please.
Yeah, I agree with what both John and Jason have said, and the whole point of flexibility, but also to me, it depends on expediency. If there's an important issue that's got to come up and the council would like to have additional voice, then appointing would make sense. If there isn't, now we can look out. We typically know 2 to 3 months in advance what our calendar looks like. So we'll know if there could be potentially a special election. So I think coming back to the key is just flexibility. And in my experience, it seems to have worked.
Thanks, Jeanette.
Just as a quick follow-up, for all 3 of you, it sounds like you would prefer to leave it exactly the way it is.
Yeah. As I'm hearing from most folks, but is there anyone who feels differently, that they do not want it left the way it is? Okay, is everyone comfortable with leaving the vacancies to the discretion of council on how to fulfill them? With the caveat that if it is less than a 1-year term that is remaining, then it would be an appointment. Okay. So next up, we've got 25 minutes, but I've got faith in this group. So we've got qualifications for office is our last topic. So the qualifications for office in the current charter just say that you must be a qualified elector within the meaning of the state constitution. So 18 years old, qualified to vote. Reside continuously for a period of 12 months or more immediately preceding the election in any area which is within the corporate boundaries. So it must be within the city for 12 months prior. Stay there for 20 days after. And then the procedures for nomination election are in line with the ORS. Karen, please.
Just wondering, did we intentionally skip the recall removal?
No, I just forgot it. I knew there was another question. Why don't we go ahead with qualifications just because it's been coming up so much this evening, but thank you. This is the second time where you've reminded me of a topic that I'm skipping. I'm very grateful for you, Karen, and your details. But qualifications, yeah, thank you. So retaining the qualifications as they are listed currently in the charter, which have to do with residing in the city, but don't have anything to do with being a elector of the city of Tigard. Or delegating this area to ordinance, which is what Beaverton has done and the LOC recommends. There's also, this group can also recommend other areas like we talked about earlier today to add to what those qualifications could be that have to do with residency requirements, as long as they are not at odds with the state law. Any comments? Karen, your hand is still up. Did you have other comments? Oh no, you're muted.
Yeah, it was still up, but I guess then I did just have a thought. It seems like if we have the what do we do? The job description in the charter, it seems like the qualifications should be in the charter as well.
I was gonna say, Shelby and I talked about this, and we weren't recommending to delegate this to ordinance. So the only thing that I've heard really come up that would be something that we could put in this qualifications that like this group would like to have added. Everything else is probably might be okay. But it did sound like this group wanted to add a requirement that the person be an elector of Tigard, which does serve another requirement. Is that something that this group would like to do? Carol, please.
Absolutely. Yes.
Does anyone feel strongly? Oh, Jason, please.
I was just going to say, if there's a no-brainer for this whole series of meetings, I would think this is it, but maybe not.
Does anyone disagree with requiring that somebody running for office be an elector of the city of Tigard? Seeing none, that will be a recommendation that we will add that to the charter, that you will be a qualified elector. So the other requirements of the city qualification is that you've resided continuously for a period of 12 months or more immediately preceding the election within the corporate boundaries of the city. So does anyone feel that this should be changed, that it should be longer or shorter than 12 months preceding an election, that you should reside within the city? And I think by our recommendation also be maybe an elector of the city for the 12 months preceding the election. John, please.
I'm fine with the 12, but there are a lot of other cities contiguous to us that are only 6 months. So, those are smaller cities. So I'm just saying that that would be a reason, maybe if somebody moved into the area, felt really strongly, wanted to do something, they still could do that. The question I always had is 6 months from when? Because when we have to sign up, I'm assuming if you sign up to apply, let's say July 1st, that it's 12 months from that point and not from the actual election date. So, or at the election date or the date you take office. So to me I think that needs to be clarified, and maybe it is, but I think the group doesn't know that. I'm fine if it was shorter, depending on what that date was.
So our charter currently says preceding the election date. So that would be the determining date. But this group can change that. Margaret, please. Oh, Margaret, you're muted.
I would almost want to go through and I agree with John to make it less than 12 months. And the reason is I've known 2 people that have been involved in city stuff, involved in things, but have not moved into the city. I mean, because of, whatever reasons, like 8 months ahead of time. And I know when there was a vacancy, I had a friend of mine that wanted to apply, but he'd only lived here for like 8 months and had moved in and out of Portland and into here. So I think that's just kind of what is. So I would almost like maybe instead of 12 months to have 8 months. And so that's 8 months from the time of the election is what my understanding is. Is that correct?
Yes, that would be 8 months before the election. Thanks, Margaret. And Zachary, please.
I think just to make it more clear, it might be better just to do 6, considering that's what a lot of other small cities do.
Thanks, Zachary. And Derek, please.
Just wondering if there's any background information as to why the League of Cities recommends it be an ordinance rather than a charter. Like, I know you indicated that that is what they do suggest, but just kind of why they might suggest that.
It's funny, Shelby and I were talking about that today and trying to figure out why. Shelby, you have any guesses? I've got mine.
No, I don't know. I mean, the Oregon Constitution, the US Constitution, they put the qualifications, well, the Oregon Constitution puts the qualifications of electors within it. So no, I mean, I think to Karen's point earlier, it's if we say that you have to be a qualified elector, we should also define what is a qualified elector.
The only rationale I could come up with is that maybe they've decided that the body should decide on their own qualifications, but I don't know if I'd recommend that. Dolly, please.
Oh, I seem to be like the unpopular thing in terms of I actually want longer term because I want the person running, to be vested. I've met, contrary to what Margaret said, I've met people who are so gung-ho, maybe qualified and whatever, but don't live in the city, therefore have not felt the culture of the city, and then all of a sudden want to change a lot in the city because they've seen something better somewhere else. And somehow I just kind of live here for a while and experience it and be part of it before you start changing it. But that's my opinion. And I'd like it to be like the 12 months prior to even raising your hand, because that gives you residency.
Thanks, Dolly. And Karen, please.
I also like the 12-month commitment, but in addition, Margaret brought up a good point that we say preceding the election, and I feel like it should be or appointment date, because her example was somebody wanting to get appointed.
That's a good point. Derek, please.
Just to echo Dolly and Karen, that I prefer 12 months as well, just some level of investment in the community. So that would be the direction I would take.
And Jeanette, please.
Yeah, I'm going to pile on here. I concur with Dolly, Karen, and Derek. And I think, Karen, that was an excellent suggestion to add the appointment and nomination.
So Karen, your hand is still up, but okay. And Margaret, please.
I can go with 12 months.
Carol, please.
Yeah, I like 12 months, and I like it before the election rather than, I think because the election could be in the, a special election, which might be held not in November. So yeah, I like 12 months before the election. I want some investment and knowledge about the community.
Thanks, Carol. Tony, please.
Yes, I'm in the 12 months camp also, but I'm also in Margaret's original camp for that circumstance where you have somebody that is actively involved in a community and in an area that's been thinking about moving into an area, that they're active in the culture, that they're learning as much as they can about the city, and they have a vested interest in coming here because they value the culture that they've learned, that they've studied the area, they love the community, and they're coming here. Basically they're a longtime member that just has never actually physically been here. Their heart's been in this location for a period of time. They just haven't been physically able to get here. I'm following some cities that I really like, and I've been involved in their social media pages and talking to their community leaders. And so I can kind of understand what Margaret's talking about in that circumstance too, but I don't know how you address that within the language, how you can, qualify, how vested have you been in, our city for the last 6 months that you actually haven't lived here. So as much as I understand the spirit of that deeply, I think having that time requirement really kind of make sure that somebody has physically been in our community and our culture.
Yeah, thanks, Tony. Great point. All right, does anyone feel very strongly that they want it to be less than 12 months? Sounds like most folks are comfortable leaving the 12, but if you feel strongly, please let us know. Okay. So that'll remain 12 months. And then there's been a couple suggestions. So right now it is 12 months preceding the election. There was, let's do one at a time. There was a suggestion to say or appointment. So if someone's being appointed to the office, they must have resided in the city for 12 months prior to that. Does anyone feel strongly? We heard from folks who feel strongly about adding it. Does anyone else feel strongly about adding it or about not including it? Derek, please.
Just going back to what Tony was talking about, like I recognize what he was saying is trying to get, if somebody's heart's in the right place, I just don't know how it is that you incorporate that into the language in some fashion that's going to be repeatable and understandable. It seems like just making it 12 months, full stop, appointment or nomination is just the easiest interpretation of it and prevents us from having to discern some unknown meeting at a later date. So my position would be appointment, nomination, 12 months, and then just that's the end of it. But I'm open to whatever other folks have to say.
Thanks, Derek. Oh, that was the other thing I was going to mention too, is that it is we are in a 2-year election cycle. So generally people might get inspired during an election to run for office themselves. And so they would have a full year or ish, almost a full year to move and then meet that residency requirement. So that does help, I think. And Nathan, please.
I was just going to say that I would support adding the appointment language just to be clear that the qualifications are the same whether you're elected or appointed.
Thanks, Nathan. And Zachary, please.
I feel like, yeah, before the election cycle is helpful. Would it be, but when would it be like continuous, like 6 or 12 months before, or would it be like?
Yes, it would be resided continuously for a period of 12 months. And then it would also be 12 months as a Tigard elector.
Okay. Yeah, I mean, that should, because ideally we want to make sure that the people we're voting in live in Tigard and they're going to like be really involved. And with already the 2-year cycle, it does sound like it's a lot easier to get more people involved with that. So that's great. I support that.
Thanks, Zachary. Does anyone feel strongly against including or appointments? Everyone's okay with adding or appointment? Okay. Nathan, sorry, you had another comment, I believe.
Yeah, I had a question actually. So I know earlier in the meeting, we kind of decided that there's no good measuring stick for residents, or that's kind of the way I was hearing it. Is that the same thing for continuous residents? Like what does that mean? If I go to Hawaii for a week, did I reside continuously?
Yes, unless you started changing your mail, your driver's license, your voter registration, that kind of stuff is what we look at when establishing residency.
So we did have a suggestion to instead, Carol, can you maybe walk us through the timeline of elections? So when do folks typically turn in their nomination, or is the nomination due? And then when is the election?
Well, you can't run, you have to wait until so many days after the primary election. And so that's usually around June 1st when we can open it up even. And then things are due, I'm going to say generally, if election day is November 8th, everything is due to the county maybe September 8th. We set our own deadlines, interior deadlines, so that people can, if they need to get more petition signatures they can. Just make sure that everything is all set and nobody misses out, misses those deadlines.
Thanks, Carol.
And then,
So,
of course, when we used to require that resignation for running for another office, we had to build in deadlines for that too.
so it sounds like it's about so if we change between election to nomination, it's about a 2-month difference in time. Does anyone feel strongly about changing it to be about 2 months earlier, which would be about the time of nomination? Karen, please.
I like before tonight, I thought we should remove the word nomination from the language because nomination is really for the partisan positions, that you're nominated for the partisan position. But maybe I just lost what Carol was just describing about what
Shelby, somebody in elections correct me on this one, but I believe you can be nominated for both a partisan position, but also nominated for the nonpartisan position. So getting like all your petitions and signatures, that's what this ORS, I think, qualifies as being then nominated for the ballot.
Yeah, so it's kind of confusing because I think we usually think of nomination as like, I nominate him to this position, and that's kind of the act of supporting somebody else, I think, is kind of how we typically think about it. But in this case, like Kim said, this is actually when the person becomes eligible to, or qualifies basically, to serve on or to appear on the ballot. Does that make sense? It doesn't look like it.
just all of the language talks about filing as a candidate. Candidacy filing. So
yeah, I think we can definitely clarify that. I think you're right. We should use consistent language and refer to it in one way consistently throughout the document. I agree that would help.
Karen, I love your close reads of all of the materials. Really, it's fantastic. Okay, so nomination / filing of candidacy. Does anyone feel strongly about changing it, or are folks comfortable with leaving it at 12 months before election? I feel like everyone's pretty comfortable with leaving it at 12 months. Okay, that's what we'll do. And with that, it is 7:25. That was a great meeting. So just to look at our calendar. So we are going to be doing recall at the start of our next meeting, as well as city officials. But I think that we'll be able to do that based on kind of our pacings at the last couple. That meeting is a while from now. So that's on July 17th. So we have a little bit of a break. So I'm glad we're not breaking a conversation in half, as we've had to do before. Then we'll have 2 more meetings in August, and then we will have a fully formed charter. We sent out the charter shell a couple of times. Nathan, we did get your comments, and we'll be addressing them this week. If other folks have other comments on the shell, feel free to send them to us. Just as a point of order for the group, I am going on vacation for about a week-ish, a little more. Starting this Thursday, and I will still be on vacation next Thursday. So the cadence of communications you get from me is going to be a little bit off, but feel free to ping Shelby. I'm volunteering her if you need anything from us.
How are we going to know it's Thursday?
I don't know.
Hey, did you get our permission?
I did get consent of council, actually.
Yeah, did you get consent?
We won't know it's Thursday.
I do always, I don't, the group doesn't know this, but Margaret always, not always, but often sends me a ping back on Thursdays going, no, I know it's Thursday. It's very fun.
It's kind of comforting, you know, it is. I'm one of those kind of people. So
the next 2 Thursdays will be messageless, but I look forward to seeing you all again later in July.
Okay, sounds good. Have a wonderful vacation.
Thank you. Everybody have a great night.
Thank you. Bye-bye.